Then we will call this business meeting of the Kalamazoo Township Board of Trustees to order at 7:14 p.m. Today, the 27th. And we're in order. Trustee Martin, care to lead us in the pledge? Sure. Thank you.
I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. We'll proceed to a roll call of board members. Trustee Martin? Here. Trustee Leonard?
Here.
Trustee Glass?
Here.
Trustee Sherwood?
Here.
Clerk Mackey?
Here.
We are missing Treasurer Robinson, and I am Supervisor Combs. I'll go ahead and move to excuse Treasurer Robinson this evening.
Support.
There's a motion and support. All in favor, please say aye.
Aye.
Any opposed, nay? Motion carries. Thank you very much. Are there any additions or deletions to or from the agenda this evening? Seeing none. We will then proceed to our first of two public comment periods this evening. Once again, if you'd like to make a public comment, feel free to step to the podium. Whichever one is more comfortable for you, you'll have 3 minutes to use as you choose. Please.
Ron Huster, 1314 Coolidge Avenue. I'd like to remind everyone that next Tuesday, August the 4th, from 6 until 9 p.m., we will be doing Westwood will be doing a National Night Out at Fraze Park. We are in Fraze Park because that's the only area that's large enough to accommodate 400 to 500 people and food vendors and all the other activities that are going on. Westwood is Westwood. Part of it's in the city, most of it's in the township. Most of the people that will be at the National Night Out are township residents. That's what it's all about. But Fraze Park is walkable. There's a lot with it. We're very proud of what we've gotten done in the last few years. But it's a great thing for the people and the neighborhood, the kids, and the police and the fire department get to get out and play with their sirens and have a lot of fun. So anybody who would like to come, we'd love to have you. Thank you very much.
Thank you. Other public comment this evening? Please.
Good evening. My name is Sean Blue, 3212 Edling Drive. First, I'd like to thank Trustee Martin for all of his years of service to the township in his various roles. I do have a concern about his current appointment to the board, and it has nothing to do with Mr. Martin and his service. During discussion of his nomination, Supervisor Combs said that the board wanted to avoid even the appearance of influencing the upcoming election, and that Trustee Martin indicated he would not be seeking election in November. I was therefore surprised to see his name on my primary ballot. I respectfully ask that the board clarify how this appointment aligns with that commitment. I also have concerns about the accessibility of township public ordinances. The Michigan Zoning Enablement Act generally requires newspaper notices at least 15 days before public hearing on zoning ordinances and zoning amendments. State law also requires the publishing newspaper to make these notices available online and in the statewide public notice repository. The most recent township notice I've been able to locate online is dated December 24th, 2024. I respectfully ask the township to identify notices published since then, explain where the public can reliably access them, and confirm that all required zoning and meeting notices are being provided in accordance with Michigan state law. Thank you.
Thank you very much. Other public comment this evening? Seeing no movement in the room, we will proceed then to the consent agenda. Clerk Mackey.
I will move to approve the consent agenda as recommended by the superintendent and supervisor.
Did I hear support? There's a motion and support. All in favor, please say aye.
Aye.
Any opposed, nay? And the motion carries. Thank you very much. With that, we will proceed to the public hearing and presentations portion of the meeting. We do have one public hearing this evening, excuse me. And this is with relation to item 7A, Zoning Board of Appeal member, relating to specifically Mr. Sean Blue. Feel free to step forward if you'd like for your public hearing. For the board and context coming into this public hearing, the Michigan Zoning Enabling Act, specifically section 601, paragraph 9, allows for a member of the Zoning Board of Appeals to be removed by the legislative body, that being this board, for malfeasance or nonfeasance in office upon both written charges and after a public hearing. Having already sent written notice, this is the opportunity for that public hearing. Specifically, and I will refrain from making a case here, but specifically, this is my recommendation for public hearing based on Mr. Blue's demonstrated lack of confidence in not just the zoning ordinance, but our township staff, including disruptive behavior in the lobby of the township hall, and a lack of confidence in the ZBA or Zoning Board of Appeals decision-making ability. To be clear, this is a public hearing. This is not the time for the board to make a decision. That would be considered at a future meeting. And so I'd ask the board not to interrupt Mr. Blue during his comments. And with that, Mr. Blue, you are free to make any comments that you'd like, and also if you'd like to present any documents for the record, you're welcome to do so. I'd
like to start out by presenting a document that my attorney sent to Attorney Sieber regarding the notice that Supervisor Combs sent to me. I would also like to note that the issues that were just stated were not in that letter. There was nothing about the conversation in the hallway, so I would have appreciated that to have been in the original letter. But
thank you very much. I'm sorry.
So good evening. My name is Sean Blue. I'm here because the Township Board has been asked to consider removing me from the Zoning Board of Appeals for alleged misfeasance or malfeasance. I take that charge very seriously and I respectfully deny it. The written charges do not identify a vote I cast improperly, a meeting I failed to attend, confidential information I misused, a duty I refused to perform, or any official act I took for personal gain. Instead, the charges are based on my participation as a property owner in a zoning interpretation matter, my disagreement with an administrative interpretation, my use of comparison ordinances to explain undefined terms, and the fact that I sought legal counsel. Those things are not misfeasance or malfeasance. They are part of a lawful public process. The issue presented to township staff, the planner, zoning administrator, and the Township Board of Appeals was whether a proposed accessory building on approximately 45.5 acres at 1902 Barney Road could qualify as an accessory farm building under Section 203A9 of the Kalamazoo Township zoning ordinance. Section 203A1 generally requires a legally established principal building, structure, or use before an accessory building, structure, or use may be constructed or established on the same parcel. Section 203A9 creates an exception for accessory farm buildings used in agricultural operations on a farm as defined in Section 103, while still requiring compliance with district setback requirements. The problem is Section 103 does not define farm or agricultural operations. The township's own staff memo acknowledged that those definitions or similar definitions do not exist in Section 103. Section 103 also provides that undefined words or terms are to have the meaning customarily assigned to them. My request was therefore narrow. Apply the ordinance as written, use the customary meaning required by Section 103, and do not add outside requirements that the ordinance does not contain. Before this matter reached the ZBA, I understood that direction had been given indicating that the proposed use would qualify as an agricultural or farm-related building. My prior public statement noted that written guidance from the township attorney indicated that this type of use would qualify as an agricultural building, and that I relied on that guidance in proceeding. After the guidance was provided, I asked for what was needed to be done to ensure that I would not end up in a, quote, pissing match with the township after the project began. I was given direction that the meeting minutes from Planning Commission would be that evidence. That reliance concern is more significant because the guidance was understood to have occurred in a public or official setting involving the township planner and the township attorney in the presence of the Planning Commission. The Planning Commission had also recently appointed a new member that day, Trustee Martin, who had more than 16 years of experience as township trustee or supervisor. This advice was not received as casual private speculation. It was received as township-level direction on how the ordinance would apply. The later staff position moved in a different direction. In the May 13, 2026 staff memo, the new planner zoning administrator acknowledged that the ordinance does not define farm or agricultural operations, but then concluded that the exemption was intended to apply to, quote, bona fide commercial farm operations and buildings customarily associated with commercial agricultural activities. That created a conflict because Section 203A9 does not say the farm activity must be commercial, and Section 103 does not define farm or agricultural operations in a way that imports a commercial standard. Even if equitable estoppel is applied cautiously against municipalities, this sequence supports a reliance concern. A property owner should be able to rely on official guidance from the township planner and township attorney, especially when given in an official setting or in the presence of the Planning Commission. If the township later determines that the ordinance means something different, the fair response is to acknowledge the inconsistency, correct the guidance prospectively, and clarify the ordinance through the proper amendment process. The concern is not merely that staff disagreed with me. The concern is that after conflicting direction was given, the township would not engage in a substantive discussion to reconcile the prior guidance, the ordinance text, and the later staff position. Instead of addressing the conflict directly, the matter was redirected into procedural and accusatory framing. I was treated as challenging staff competence rather than asking for an ordinance interpretation. The use of comparison ordinances was characterized as an improper attempt to import other municipal language, even though the purpose was to show how other communities expressly defined these terms when they wanted a narrower meaning to apply. There is also a procedural concern regarding public notice. The matter was framed and processed as a text interpretation of Section 203A9, but the text interpretation was not published as a public notice in the local newspaper. It should also be noted that the Michigan Public Notice website, which aggregates public notices throughout the state, does not show any newspaper-related public notice for this matter or any other township matter since December 2024. That omission matters because the public-facing notice process is part of how residents understand what issue is before a public body and whether they wish to participate. If the matter is treated as an interpretation of ordinance text, especially one involving undefined terms that may affect more than one property, the absence of local newspaper notice creates an additional concern about transparency, process, and the adequacy of the public record. The removal says I advocated for amendments and suggested that language should be copied from other ordinances. This is not an accurate description of my position. My public statement said that if the township wanted a narrower definition, that is a legislative amendment issue, not something that should be created by administrative interpretation. That is a distinction, not misconduct. There is also misdirection in the charge that the ZBA cannot consider text that is not in the Kalamazoo Township ordinance. Of course the ZBA cannot amend the ordinance or replace it with another ordinance, but the ZBA was not being asked to do that. When an ordinance uses undefined terms, the ZBA has to determine their ordinary and customary meaning. The township's own staff memo did the same thing when it applied a, quote, commonly understood interpretation and then added concepts like bona fide commercial farm operations. These words are not in Section 203A9 either. In other words, The accusation treats my comparison material as improper external text, while staff's own recommendation relied on an external, narrower standard that the ordinance does not contain. The removal letter also says I question the competency of current and former staff and the township attorney. I did not attack anyone's personal competency. I questioned an interpretation. Public officials and applicants and residents must be able to question whether an ordinance has been applied correctly without having that disagreement turn into a personal misconduct charge. Finally, the removal letter treats my counsel's contact with the township as evidence of conflict and lack of fiduciary duty. I disagree. A private citizen does not lose the right to seek legal advice because he also volunteers on a public board. The charge does not identify any improper action I took as a ZBA member. It does not say I voted on my own matter, influenced another member improperly, disclosed confidential information, or used my office to obtain special treatment. If there is a conflict in a particular ZBA case, the ordinance already provides a remedy. A member can abstain, and an alternate member can be called to serve for that case. That is the ordinary procedural solution. It is not a basis to remove a member simply because he asked for advice or preserved his rights in a matter involving his own property. The fair reading of the record is that this is not misconduct by the property owner or ZBA member. It is an unresolved ordinance interpretation problem compounded by conflicting township guidance, reliance on that guidance, a failure to meaningfully discuss the conflict, and procedural concerns, including the absence of local newspaper notice for the text interpretation. Disagreement with staff is not misconduct. Asking the board to apply the ordinance as written is not misconduct. Using comparison ordinance to explain why missing definitions matter is not misconduct. Seeking counsel is not misconduct. The board should also be concerned about the appearance that removal is being pursued because I exercise protected rights, including speech, petitioning government, and retaining counsel to represent my interests. The removal letter states that the process was initiated after my attorney contacted the township attorney. That sequence creates a serious concern that the proposed removal is retaliatory rather than based on actual misfeasance or malfeasance. For those reasons, I respectfully ask the township board to reject removal. The record does not support misfeasance or malfeasance in office. It shows a resident and ZBA member using the process available under the ordinance to ask for an interpretation, making arguments from the text, and disagreeing with an administrative interpretation in a public forum. I respectfully ask that the request for removal from the Zoning Board of Appeals be denied. Thank you.
Thank you very much. Moving forward, we have no old business this evening, so we'll proceed to new business. First is the potential motion to adopt ordinance number 646 that is related to specifically the moratorium or proposed moratorium on battery energy storage facilities. Did you have something, Superintendent?
I have one correction. 646 is the correct ordinance. We spoke about it at the last meeting. We spoke about it at 645.
Okay.
But this motion does reflect 646, and the resolution can change to 646.
Great. And that does look to be reflected in the draft ordinance here as well. Thank you. Okay, I'll make a motion. I will move that we adopt ordinance number 646, the moratorium on battery energy storage facilities, as presented and previously presented for first reading, excuse me.
Support.
It's a motion and support. Any discussion? Seeing none. We will proceed to a roll call vote. Trustee Glass.
Aye.
Trustee Martin.
Aye.
I'm an aye. Trustee Leonard.
Aye.
Clerk Mackey.
Aye.
Trustee Sherwood.
Aye.
And the motion carries. Thank you very much. Second new business item this evening is the motion to adopt ordinance number 647. That is the proposed moratorium on data centers, also presented for first reading at our previous meeting.
I will move to accept ordinance number 647, the moratorium on data centers.
Support.
It's a motion and support. Is there any discussion on this one? Seeing none. Sorry, trustee Sherwood, did you have something?
No.
Okay, fair enough. With that, we will then proceed to a vote. Clerk Mackey,
Aye.
trustee Sherwood,
Aye.
trustee Leonard,
Aye.
I'm an aye, trustee Glass,
Aye.
trustee Martin.
Aye.
The motion carries. Thank you very much. That concludes our new business, this evening. No items were removed from the consent agenda, and we do not need a closed session this evening. So we will proceed to our second public comment period this evening. Once again, if you'd like to make a public comment, feel free to step to the podium. You'll have 3 minutes to use as you choose.
Danielle Blue, 3212 Edling Drive. Good evening. My name is Danielle Blue, and I'm Sean Blue's wife. I'm speaking today because this removal hearing is not just about a board appointment. It is also about whether a private citizen who serves on a township board still has the right to question a decision, seek clarification, and protect his interests when the township applies its ordinance in a way he believes is incorrect. First, if the assumption is that becoming a member of a township board means a person forfeits constitutional rights as a private citizen, that should be made clear before people agree to serve, not 7 years into their tenure. I do not believe many people would volunteer for township boards if they were told in plain terms that they could not use the same appeal, interpretation, counsel, or petition rights available to every other resident. If only people who are not board members may follow the ordinary process after receiving a decision they agree with, then that limitation should be written clearly into the ordinances. Residents should not have to discover that rule only after they have relied on the process that the township itself provides. Second, Section 1101 of the Township Zoning Ordinance, R1 Single Family Residential District, includes a statement of intent encouraging the preservation of open space, protection of flood-prone areas, protection of wooded areas, and preservation of natural features. Since we purchased the first 6.5-acre parcel in 2017, followed by the additional parcels totaling approximately 38 acres in 2019, that has been our mission. We have tried to preserve the land where we can and maintain a healthy habitat for the wildlife that uses it. We have also put in walking paths for our own use and for neighbors we allow to use the space. Those paths also help create access if the township needs to reach the sewer easement for maintenance. Maintaining 45.5 acres takes equipment. It takes mowing, clearing, trail maintenance, security work, and regular access across the property. The practical question is simple. Where is that equipment supposed to be stored if we are not allowed to build a pole barn? Are we expected to rent a mower, tractor, skid steer, or other equipment every time work needs to be done? Are we expected to own or rent another property somewhere else just to store equipment used to maintain this land? We already have a home in the township in a platted community near this property where housing more reflects the stated desire for the R1 district. Right now, we have approximately $40,000 worth of equipment stored in a small shed and a canvas carport on land that sees more than its fair share of trespassers, despite signage and cameras. A building large enough to store that equipment would allow us to secure it, protect it from theft or damage in the elements, and continue maintaining the property responsibly. I would also like the board to consider who is actually harmed by a storage building on 45.5 acres. We have no objection to the parcel being reassessed, and we understand that a permanent structure may increase the taxes we pay. Our neighbors have not objected to the building, and they have indicated that it would not negatively affect them. I understand there may be some concern that someone could live in the building. That is not what we proposed. The building would not have running water or heat, and it is intended for equipment storage. In addition, as we understand the ordinance and permitting requirements, residential occupancy would require approvals and utilities that are not part of this proposal. The planner's presentation at the ZBA meeting appeared to assume facts that were not in evidence. A number of assumptions were made about what we were trying to do, but instead of allowing these assumptions to be clarified through basic face-to-face conversation, the planner refused to meet with us to discuss them. We never said we did not intend to pull a building permit. We never said the proposed 30 by 50-foot building would occupy the area that had been prepared for a prior house site. We were asking to store equipment used to maintain and preserve the property. That context matters to this removal
Thank you very
hearing.
much. Appreciate it. Other public comment? Seeing none in the room. We'll then proceed to superintendent comments. Superintendent, I'm sorry, you're not able to present materials during public comment. The public hearing is over. They can be submitted to the superintendent in writing. Thank you. Superintendent, your comments.
Thank you. I have one item, I'm bringing this forward. We just received a request from, Baptist Church requesting, similar to Trench's Church, they're gonna have an event. They want a small portion of Riverside between Lake and Carlton closed for one of their, church events. They need to fill out the road commission application. We reviewed it from the
very much. With that, we'll proceed to board member reports. Trustee Leonard.
No reports tonight.
Thank you very much. Trustee Martin.
No report.
All right. Trustee Sherwood.
No report.
Trustee Glass.
No reports made.
Easy evening. Clerk Mackey.
I just wanted to let everyone know, you probably know, but next Tuesday is Election Day. So you have different options available to you. You can vote in person at your precinct. We've sent communication to everyone affected, but there was a permanent consolidation of precincts. So if you're not sure where you vote, you can either call our office or you can go to michigan.gov/vote to just confirm that information of where your polling place is. There are also 9 days of early voting. So we're in a intergovernmental agreement with the county. So there are 4 sites throughout the county where you can go to do that. That information is available on the County of Kalamazoo's website. We also have a brochure out front if that's something that interests you. And you can also vote with an absentee ballot. So you have 3 different ways to vote, whatever is convenient for you. So, thank you.
Thank you very much. Just a couple of things this evening. First, an update I received just earlier today, and hopefully my last update related to the various legal cases that the township was involved with former Treasurer Shereen Miller. After our previous meeting, and this board authorized me to sign the settlement agreement, which involved Ms. Miller repaying the township $10,000 from the original settlement agreement, which remains in force. We've received word that the Ninth Judicial Circuit has, according to the terms of the agreement, dismissed all, both of our remaining claim and Ms. Miller's counterclaim. And so the matter is effectively closed. We did receive payment. Actually, I think we received payment prior to us even approving the agreement, but that payment has been received, I believe deposited, so the matter is entirely closed. And her attorney, Mr. Brad Seisel from the Herbert Machnick Law Firm, should have also received that and on his own terms, and the matter's closed, so we should not need to discuss it again. Thank you all again for bearing with us through that. The last thing I had, just a quick reminder, as in a future meeting, we will need to take up the item which was discussed during the public hearing, the potential removal of Mr. Sean Blue, the Zoning Board of Appeals. A reminder again that the decision which will be before the board is whether grounds exist for removal from the Zoning Board of Appeals, not a reconsideration of the Zoning Board of Appeals voted decision. That's all I have this evening, and with that, a motion to adjourn would be in order.
I make a motion we adjourn.
Support. Motion support. All in favor, please say aye.
Aye.
Aye. Any opposed, nay? And we're adjourned at 7:42. Thank you all.